So thank you for joining this webinar. I put it together in quite a short time period because of the potential urgency, but I recognised due to lack of any particular specific guidance around this particular coronavirus related issue that it might be useful for organisations, particularly those in the hospitality industry, to get some background on GDPR and how the obligation to record for test and trace purposes how GDPR impacts on that. So we're going to be running through basically a recap of the main areas of GDPR, and also look at some of the considerations when we're considering what it is that pubs, bars, restaurants, cafes, I think even takeaways are included in the list, are planning to open from the 4th of July, and specifically looking at this issue around the requirement to record customer details, particularly this will hopefully be particularly useful to anyone who has not needed to record those kind of details in the past. So just very quickly, an introduction. My name is Mark Gracie. As I said before, I run a business called Mark Gracie GDPR, does what it says on the tin. I support businesses with their GDPR compliance. I run various different helplines, some online resources, and also run webinars like this. And I'm currently, I think it's week 8. We've just finished week 8 of my weekly GDPR workout. So I do training sessions as well for businesses to get their heads around some of the complexities of GDPR and understand how it applies to their business. My background is in data protection compliance. I became a data protection manager back in the late 90s when the 1998 Act came into play, and that was the beginning of a 15-ish year career in regulation focused around data protection, internet regulation, telecoms regulation as well. I was working in the internet industry in that period. And I've been running my business for the last 4 years, as I say, working with businesses to ensure their GDPR compliance and also their marketing compliance. So I provide a lot of assistance to businesses looking at the privacy electronic communication regulations and what you can and can't do with personal data for the purposes of marketing as well. So what are we all here to talk about today? Well, the government guidance that was published last week, following from the Prime Minister's announcement that from the 4th of July, certain organisations in the hospitality industry are able to open, but have to be COVID secure. And the key statement from the guidance, there's a link at the bottom. I'm sure you will have seen it already, but there's some guidance around helping those industries, those organisations understand what they should be doing and how they can be COVID secure. And one section about how to protect customers and staff is this quoted a couple of paragraphs that basically that you can help assist the NHS Test and Trace programme by keeping a temporary record, and by temporary they say 21 days, of the customers and visitors to your business, and it needs to be manageable in a way that your business and the NHS Test and Trace programme can request details for the purpose of test and trace. And I'm sure you all understand the test and trace is about being able to track people who may be needing to isolate because of somebody they come into contact may have tested positive for coronavirus. So I've highlighted there in the first paragraph the sort of the key bit which we're going to be covering today, and in the second paragraph the other key bit, which is I guess from people working in restaurants, hotels, etc. The thing that's missing for them is the exact guidance about what this temporary record of customer data is likely to look at, and it makes reference to data protection legislation, but doesn't actually say what that means in reality. And so that's what I'm going to be covering this afternoon. Now, there's a possibility, and I add a caveat here. There's a possibility that the government will come up with a set way in which you're supposed to record the data, or a recommended application, or some other means to do the recording. And they may also set out certain things which they expect you to do, some of which I may or may not cover. So without knowing, and certainly unless this has come out in the last few hours this morning, unless they have published any other guidance, I'm basing this on the fact that actually it's not clear what it is that you're going to be asked to do specifically in terms of the action, only that you're to keep a temporary record of data of customers and visitors to your premises. And you need to have that to hand in case NHS Test and Trace want to have access to it. And possibly data protection being mentioned, we could see some specific guidance from the Information Commissioner's Office, although I suspect that that's probably just going to be like a checklist, checklist of what bits of GDPR apply. So somebody's just asked me, what's the paragraph? Off the top of my head, I think it's 2.1. It's certainly, I think it's in the section that's titled how to protect your customers, and it may even include staff. I can't remember if that's the title, but I think from the top of my head, I think it's section 2.1. So when we look at what this means in reality, what is the problem? Well, you're going to be potentially recording data that you've not needed to do before. Obviously, if you're using an ordering system, then you may already have systems in place, so this may be less relevant to you. But for organisations like a high street cafe who may not know who their customers are coming in the door, normally they've now got to put in place these processes, so they'd be recording data that they've not had to record before, so they therefore don't have processes in place or systems in place. But potentially for organisations that even have an ordering system in place, for the sort of ad hoc visitor, again, they may not have a system in place, but potentially they're recording data about individuals that they wouldn't normally record. And there's a question about how that will actually happen in terms of the medium, whether you're using paper, an app, or some form of other technology, maybe a computer or a spreadsheet or something like that. The next thing to consider is how that, and this is what today's session is about, how's that handling of this new data need to be carried out based on the UK law, which in the UK we have the GDPR, the General Data Protection Regulation, which is a European regulation but still applies, and whilst we're in transition, it's still EU GDPR. Post-Brexit we will have, so post the transition, we will have a UK version, which will be called, I think it's UK GDPR is the correct name, but for all intents and purposes, it's GDPR. And we also have in the UK the Data Protection Act 2018, which firms up certain changes that are allowed under GDPR, or particular things that have been added on by the UK government. You've got the issue of dealing with the NHS and their test and trace. How do you know it's them that's calling you or getting in contact with you? How will that mechanism work? Again, I've not read all of the guidance in detail, but I suspect that there's probably a mechanism in place that will set out how that would work, but you need to be sure that you're following whatever protocol that they would be following to make sure that you're actually dealing with them. And as I said at the outset, there's no clear guidance from the government about how you're expected to implement this, if there's going to be a standardized way of doing it, whether it's being left up to you, and so forth. So this is really the key part of what we're going to be looking at over the next hour or so. But first of all, let's have a very quick recap of GDPR, and forgive me if it's a bit too basic if you're fully up to speed on what GDPR means, but I just wanted to sort of set the scene by covering the basics of GDPR, and then we'll get on to what that means for the problem at hand. So data protection law, GDPR, is all about the protection of personal data. So this slide shows a number of key definitions. There's lots of definitions in the law, but these are the key ones, and probably the terminology that I may use as I'm speaking. So as I said, GDPR is all about personal data. Now, personal data is any data that enables you to identify an individual and that may be directly because it actually relates to them and you can see their name or some other identifier, or indirectly because you have a pot of data that may be having something like a customer ID, which on its own doesn't look like personal data, but when you tie it in with the fact that you know that customer ID 1 is Fred Blogs, then both pots of data become personal data. And also anything you store about an individual, maybe an opinion or a discussion that you've had on a customer note or something on a database, that's all constitutes personal data as well, and would form part of that individual's data that you store on them. So when we're talking about data protection, we're talking about personal data. So when we're talking about recording customers, you're likely to be recording, I guess, their name and a contact detail of some kind. That all of that information you collect will be personal data, and therefore GDPR applies. There is a subset of personal data called special category of data. You are, for the purposes of this recording that you have to do, you're unlikely to need to have special category of data being recorded, but it relates to things like health information, sexual orientation, religious beliefs, trade union membership, biometric data relating to, for the purposes of identification, and various other categories of data. So for example, employers are looking at how they get their employees back to work safely, and they're doing various different things. They might be recording temperature checks as they come into the office, that kind of thing. Those temperature checks, if they're being recorded and processed, depending on what they're doing with it, with that information, that will constitute special category data. What you do with the data is called processing, and processing has a very wide definition. It relates to pretty much anything you're doing. So it's not just why you have the data in the first place, but it's the storing of the data, the editing, the deleting, the manipulating, the sharing. It is literally everything. And because of that wide definition, you have to bear that in mind when you think about the use of personal data, because you're probably processing data, or organizations are processing it for you without necessarily thinking that that would constitute processing. So it's not just why you've got the data, it's everything that you do with that piece of data. The data subject, well, so here the next three definitions are all linked. They're the main key players when it comes to data protection. So you have the data subject, who's the individual whose data it is that's being collected and processed. You have the data controller, who is the organization who is collecting the data from the data subject. And you may have a third party called a data processor who processes the data on the data controller's instructions. So in a very, I usually use an email marketing scenario, you as a business collect email addresses for marketing purposes. The email addresses relate to the data subjects. You're collecting them and determining what you're going to be doing with them, which makes you the data controller. And the organization that you might use to actually send out your email marketing, you might use a third-party marketing company, they would become a data processor. So you don't always need a data processor. Your employees working for you are not processors, they're employees of you as a controller. But essentially, if you're collecting personal data, so in the topic that we're talking about this afternoon, you're collecting the names and contact details of visitors and customers to your premises. That makes you a data controller. The customers and visitors are the data subject. If you do something else relating to the processing of that data that involves another party, and we'll talk about a bit more about what that could mean a bit later on, then they would be a data processor. Now, the rules about what you can and can't do are referred to as the principles. And in GDPR, there's, I've lost count. There are 7 of them. Firstly, you have to process everything lawfully, and we'll talk about the lawful basis for processing in a second. And we'll also talk about it a bit later on because it's very relevant to the discussion we're having. So you have to be basically, it must be legal for you to do the processing. You have to be open and transparent about what you're going to be doing, so that it should not be a surprise to anybody to find that you've got their data and how you're processing it. What you're processing should be only for the specific purpose that you want to use it for. So if you're collecting it for one particular reason, that's the only reason that you can process it, and it would be unlawful for you to process it for anything else unless another lawful basis for processing applies. So for example, collecting names and addresses of people coming into your venue the purpose is because you need it for the NHS Test and Trace. That's the only purpose that you can use that data, unless you put other steps in place to confirm that you're going to use it for something else. So, for example, to be added to an email list or something like that. And again, that other purpose would need a lawful basis for processing. The data you collect has to be relevant, so you don't ask for things that you don't need. So if the government, for example, came forward and said, okay, the test and trace, what we need is a name and a telephone number, that's all that you should be collecting. If you collect any other data, then you've got to consider whether it's lawful for you to do so, and be very clear as to whether it's relevant for whatever purpose that you're planning on collecting that other data and processing it for. You have to keep the data accurate and up to date. You must only keep it for as long as it's lawful for you to do so. So in the terms of this data that's being collected, that's being defined as 21 days. If you use any data for any other purpose, then you have to be very clear about what you keep that for, and that might be governed by law. So tax law, for example, tells us that we must keep 6 years plus the current year for certain information for tax purposes. Well, if that includes personal data, then the law tells you that you must keep it for 7 years, and therefore it's okay to keep it for 7 years. Otherwise, if you don't need it, you must delete it. Or if there's no legal obligation to keep it, then again, you must delete it. All processing must be done securely. And often when people talk about data protection, this is one of the key things that they think about. It's the security of data, and we'll talk a bit more about that a bit later on. But essentially, the law says you have to implement appropriate technical and organizational measures to protect the personal data and make sure that it's not unlawfully accessed, unlawfully processed, stolen, or whatever. And finally, introduced in the GDPR was the accountability principle. This is a new principle that basically says it's okay that you think that you might be compliant, but you actually have to prove it. And there are various elements, and we'll talk about accountability in a bit, various elements that you need to consider and put in place. So if you've never processed personal data before, for example, then you'll need to think about these various accountability requirements as well. So these are the rules. In the top left-hand corner is a little blue box that says the rules about transferring data outside the European Economic Area. So under old data protection, this used to be a principle, but it's essentially another rule, which basically says you're not allowed to process data outside of the European Economic Area unless there is a adequacy decision. So that means the EU have confirmed that the country that you might be transferring to has declared themselves as, they've checked them out and made sure that they've got equivalent data protection law. For example, New Zealand has an adequacy decision, Israel does. Countries like US and India and China don't. So the next thing to look for is whether there's an independent agreement, and there is a US-EU agreement called Privacy Shield, which is US companies can sign up to it and say that they will apply European standards of data protection when processing European citizens' data. And if there isn't an adequacy decision or there isn't an agreement, then it comes down to using legal contracts, of which certain types are defined in law. You have to cut and paste them into a contract with the processor. The law is dictated, so you have no choice. It really is a cut and paste. So that's just to set out the scene that actually if the data was being processed outside the EU, then there may be some other issues to consider. Now, you might be saying, well, why is he going on about non-EEA data transfer? Well, actually, if you remember that, what I said about processing, having such a wide definition, if you stored your customer list on Dropbox or on a cloud storage service or in a database where the data is being hosted outside the EEA, then you are processing data outside Europe, and therefore that element of data protection applies. So the fact that you might be using a third-party cloud-based system like Dropbox, like OneDrive, if you use Microsoft Office, for example, or if you're using an app that might store the data for you, you need to understand where in the world that data is being stored, because if it's being stored outside the EEA, you have to do these checks to make sure that the right protections are in place. So those are the rules. The lawful basis, every processing activity needs to have a lawful basis associated by it, and you have to determine what that lawful basis is. Now, lots of people automatically think that that's all about consent, and when there was the GDPR coming into play in May 2018, when it came into force, we were all inundated by these consent messaging, and a lot of them probably unnecessarily. But the consent messaging, the consent is that is a very black and white binary lawful basis. Either somebody does give you permission or they don't give you permission, and there's nothing you can do about it. So if you're asking them to do something, if you're asking them for data and you're going to be doing something with it regardless, consent is not the most appropriate lawful basis, even though most people know about consent. So don't always default to consent. Think of it as that yes, no, that binary decision. Contract is a lawful basis. So if you're processing the data because you are delivering a service or a contract, or you're entering into a contract, then lawful basis would be contract. Not, you don't have to also say, as you're a customer, I need your data to be able to deliver the service. Can you consent to me processing it in this way? You don't need to do that. You need to set out that that's what will happen to the data in the from the processing of it if it's not obvious. But you don't need to ask consent as well, because your lawful basis would be contract. You may be obliged by law to process the data in a particular way. So I mentioned HMRC asking you to process, to store data for a longer period than you might need it for. Well, you're legally obliged to keep that data. So therefore, that processing, that simple storage in terms of processing would be covered by that as a legal obligation, and various different sectors are covered by certain types of regulation which may oblige them to keep data longer than they need it for, or to do something with the data which they wouldn't normally need to do it. So if the law applies and tells you you've got to process data in a particular way, then that's your lawful basis is legal obligation. Now there are a few others. Vital interest is very much a life or death scenario. This relates to the data subject and processing their data. If you are able to ask the individual, then you can't rely on vital interests. But if you need to process data and for example, if an employee collapsed at work and you knew something about that employee, you wouldn't have to think about, well, which is my lawful basis for processing? Can I tell the paramedic this information or not? You don't need to worry about that. If you can't get in touch with the individual, so if they've collapsed and unconscious, for example, then you can rely on vital interest as your lawful basis. Public task will apply to public authorities or people working on behalf of public authorities, and they're basically so for example, a council may process certain data for a particular purpose, and they'd be doing that as a public task, and that would be their lawful basis. And finally, something else which is quite popular is people to say, well, if I can't get consent, or I'm not really sure what's going on, I'll just default to legitimate interests. So if you can demonstrate that it is in your interest and there really is no other way you could process the data, and it's not harmful to the rights and freedoms of the data subject, then you can claim that you have a legitimate interest in that processing. It's a bit more complicated than that. I don't have time to go into that complexity, and there's a 3-point test that you should carry out to be sure that you are absolutely adamant that legitimate interests apply. And if you were processing special category or criminal offence data, then there are additional conditions which have to apply as well. So you have to have a lawful basis for processing and also one of the special conditions. So that's the lawful basis, and the key thing is you understand what they mean and choose one that applies to the processing. And the processing you do on a single piece of data, you might do different things for different reasons, and therefore you might have multiple lawful bases for those different processing activities, but you must have one lawful basis for any of your processing activities on personal data. All the data subjects have individuals' rights, and this chart, I'm not going to go through all of them, just pick out the key ones, but data subjects have rights which you must abide by. So the obvious ones to talk about is the right to be informed. So this is a right for the data subject to know what it is that you're doing with their data. So they have to, so you have to provide things like a privacy policy, which sets out that you have their data, how you're going to be using it, how long you're going to be keeping it, why it's lawful for you to have it, who you're going to share it with, where it's being processed, and so forth, as well as some specific things which are listed in the legislation. And that's the bit, the right to be informed is why we have privacy statements, privacy policies, privacy notices. They all amount to the same thing. It's about explaining to an individual that you have their data and what you're going to do with it. And there's an extra additional set of things you have to do if you didn't get the data directly. Obviously, if you're collecting the data from the individual, then what you need to do is you always need to set out exactly what's going to happen with that data and what you're going to be doing in it, and that's why you would have some kind of privacy statement or point people to your privacy policy, which you might have on your website. The right of access or subject access requests. This is an individual right which entitles the individual to be told what data you have on them, that you are processing the data, what that data is, and provide them with a copy. You get a month in which to do that, and that's a calendar month, and you have to provide them what they request, and for free. There are some exemptions to that, but generally speaking, they can ask for everything and you have to provide everything, and you can't charge them for the time and effort in doing that. There's a right to rectification which is part of that principle around keeping information accurate. Right to erasure, which is somebody can tell you that they want to have their data deleted if you don't need it anymore. It's not an absolute right, which means that you can say, well, actually, I've got a lawful reason to carry on processing that data, and therefore I'm not going to delete it, but you have to set that out. The other one that I'm going to just touch on is very briefly is the right to object. So that's the right for somebody to, if they've given you consent to do some processing, they've got the right to change their mind and say they don't want you to process their data like that anymore. So when we talk about marketing, typically the unsubscribe or the right to unsubscribe or withdraw consent is this right to object in action. There's obviously a lot more detail to that, but I haven't got time this afternoon to go through that in too much detail, but we'll touch on some of these as we go through some of the challenges that this new guidance puts upon you. And finally, in the recap, the accountability principle. So this I touched on as one of the data protection principles. It's a new one that GDPR introduced, and there are various different things that you have to do or consider doing, and it's about proving and demonstrating your compliance. Probably the most significant, lots of people have heard about the use of DPOs and data protection officers. Not many businesses will need to have them. There are certain conditions where you're mandated by law to have one, but most organizations probably don't need to have one. The other one that is very key is the ability to demonstrate that you know what data is being processed. So that's having documentation that sets out your core processing activities. Larger business, over 250 employees, have to document every processing activity, but under 250, you just have to have a documented evidence trail of what data you process on a regular basis. This document needs to be accessible to the Information Commissioner if they want to, so you need to have it to hand. If they were to ask you, you need to be able to hand it over, for example. There's some other checks and balances which form part of documentation as well. So I talked about legitimate interest as a lawful basis for processing. The 3-point test is called a legitimate interest assessment, and it's about demonstrating you've worked through being sure that legitimate interest is in fact the most appropriate lawful basis for processing. On the other side of that, that diagram is data protection impact assessments, which are a risk management exercise in understanding the risks from your processing and how to mitigate them. Just going back round slightly, policies and training, that's about how can you demonstrate, and this goes with the auditing and the documentation and understanding what data you have, how can you demonstrate your compliance if you aren't clear on what data you have that you're processing, which is where the auditing and documentation comes in. You don't have any internal procedures to fall back on which demonstrates what you should or shouldn't do in certain circumstances, and more importantly, your employees should do and shouldn't do. And how can you demonstrate your compliance if your employees aren't aware that they need to worry about data protection? And you know, I've seen quite a lot of media just recently talking about this challenge that the hospitality industry are finding themselves in, because they've got to record customers and visitors coming to their premises, with people saying, and there's been evidence, I think there's been a few cases in New Zealand where members of staff have not understood that they had to worry about the privacy of the people that they're writing it down, so they're using the data for something else, or they're I think they were harassing them on Facebook, I think was one of the issues in New Zealand. So if you set out in your policies what your expected data protection behaviours are, and you give a basic understanding to your staff about data protection so they can relate to how data protection applies to their day job, then that puts you in good stead to be able to demonstrate your compliance, which is what accountability is all about. Now, if you're using a third-party processor, remembering processing has a wide definition, and third-party processors will be organizations who are doing something with your data, and that could be simply storing the data. So if you're using an app, for example, then they will be storing the data somewhere, and if it's not on your device that you're running the app on and they're storing it in the cloud, or you're using a CRM or some other kind of database that's hosted outside of your organization, then they will be considered a third-party processor or a data processor, and the law requires that you carry out due diligence on them to make sure that they're GDPR compliant, and also that you have a contract, usually called a data processing agreement, in place with the processor that binds them to certain conditions. And these conditions are actually set out on the face of the law. So you have to implement a range of different things, which range from very obvious things like you must process the data according to our instructions, right through to we have a right to come and audit you if we want to check you out and make sure that you're compliant, and so forth. And then just moving around clockwise, I did data protection impact assessments just a second ago. Codes of practice and certification schemes are allowable under GDPR. We don't have any in the UK right now, although the Information Commissioner do publish certain best practice and code of practice documents. And from what we're talking about today, I don't think there's anything particularly relevant with this particular recording requirement. But as always, there are different guidelines about what you should and shouldn't be doing with the personal data, and it's difficult for you to defend your position on compliance if you don't follow what's deemed to be best practice, be that sector specific or because the Information Commissioner tells you you probably ought to do it this way. And finally, something that I think quite a lot of organisations forget is that GDPR wasn't just about May the 25th in 2018. It's actually about continually being compliant, so maintaining your compliance, keeping up to date with any changes and so forth. These are all things that you're expected to do to maintain and demonstrate that compliance, and that's what the accountability principle is all about. It's not strictly a part of the accountability principle, but in the top left-hand corner is a little box there that says breaches. There are obligations about reporting data breaches under certain circumstances. So if data gets accessed unlawfully, stolen, incorrectly deleted, or accidentally lost, or whatever, those would all constitute a data breach, and you have to make a decision about whether it's risky enough for the data subjects to warrant a reporting to the Information Commissioner's office, who's the regulator, or if you've got to also tell the data subjects themselves if there is a high risk to them. So that will depend on the context of what's being stolen in terms of what kind of data, how many people are impacted, and what the impact would be on them if that data got out into the public domain. So that was a very speedy, just over 35 minutes run through of GDPR. It is quite a complex area, but hopefully I sort of try not to oversimplify it, but give an overview of what that is all about. So let's then consider what that looks like from the problem that we're addressing today, and this requirement for the hospitality industry to record customers and visitors to their venues. So you have to think about, and we'll talk about these in a bit more detail in a second, as a sort of like a preemptive summary slide. What is your lawful basis for processing? Why have you got the data? What you're going to be doing with it? What specifically are you collecting? How long are you going to keep it? Well, that's easy. The government says you should only keep it for 21 days, and it would be difficult for you to defend keeping it longer unless you were using the data for some other purpose, and then you need to make sure you have a lawful basis that applies to that other purpose. What do you do if an individual serves you with a subject access request for the data? You know, that data I gave you when I walked into your bar the other day, can you tell me what you've done with it and all those kind of things? That's the subject access. So you need to understand what you do with that. There's obviously questions around how do you meet that right to be informed with regards to privacy statements? How do you demonstrate your compliance? And that will depend on what medium and the ways in which you're storing data, and we'll touch on about that in a second. And again, depending on how you're doing it and what you're using, how do you make sure that that data is secure? And there's, you know, it's not just about the technology. It will be about what your people, your employees are doing, and how do you make sure that they protect you as well. So I'm going to run through these key areas essentially, and talk about those in a little bit more detail based on what we've covered already. So when it comes to the lawful basis, remember you have to have a lawful basis for processing. When we're talking about customers, the data that you're collecting when they arrive at your venue, you need to have a lawful basis for doing that. Now, there is a question, and this is one of the areas where it's not entirely clear from the guidance as to which lawful basis would apply. Consent is not likely to be the most appropriate because you're being expected to record that data, and if somebody says no, then does that put you at risk from a health and safety point of view? Is it under contract? Well, if you're saying to somebody, you can come into my venue, but you need to book in advance and we need your contact details so that we can tell you if something happens, like we have to close or something like that, and you're processing the data within the terms of that contract agreement, so that's somebody booking on to come to your venue for drinks or whatever, then it's possible that contract could be the lawful basis for processing. And then the other potential option is legal obligation. Are you obliged by law to record this information as people come into your venue? Well, the guidance is guidance. I don't think it's legally binding, but it probably fits within the remit of health and safety law. So if you are obliged by health and safety law to record this information as part of a wider picture of maintaining public and employee safety, which is more likely, then legal obligation is probably the most appropriate lawful basis for processing. But as I said at the outset, if the government produce the guidance they say they're going to produce, they might set this out for you, and they might be more specific. I think legal obligation is probably the most likely lawful basis, on the basis that you have a legal duty to protect your customers and your employees from a health and safety point of view. And of course, coronavirus is a health crisis, and therefore that's why I think under health and safety law, legal obligation is probably your most appropriate lawful basis. You can't rely on vital interests, because you can talk to the individual because they're coming into your venue, and vital interest only applies when you are unable to get the permission that you might need to process the data, even if it's in their interest. If it's in their interest and you're able to talk to them about it, then vital interest doesn't apply. It's when you can't get their permission to do it or whatever. So vital interest and consent, probably not, most likely not appropriate. Contract is a possibility, but I think you'll be relying on recording these customers' names and details, contact details, for the test and trace purposes as a legal obligation around the health and safety law, not so much around the fact that the guidance asks you to do it. So what's your purpose for processing? Well, the guidance requires it, but what else might you want to do? So if you're just literally only recording it because the guidance asking you to record that information, then your lawful purpose is because the guidance requires it and you're using it purely for that purpose. So what that means in reality, in GDPR sense, is that if you're collecting it purely for the purposes of maintaining this 21-day register of attendees at your venue, because you want to follow the guidance and the guidance asks you to, that is the only reason you can use that data, unless you've introduced some other checks and balances relating to other uses. So for example, if somebody walks into your cafe and you say you need to register using this device, or I need to take your name and a telephone number, or whatever the data might be, you need to set out clearly what you're going to be doing with that. If it's just purely for the COVID guidance, then that's fine. That's your purpose for processing that data, and that's lawful for you to do that. But if you want to do something else with that, so you think, actually, there's an opportunity here, I'm going to be getting all this data of people coming in that I wouldn't normally be able to contact, perhaps I'll start marketing to them, or send them emails, or give them, send them special offers, or whatever. You've then got to think, actually, that's an additional purpose for your processing, and what's the legality or the lawfulness of that processing. So you can't just collect the data because the guidance tells you and then keep that data and use it for your email marketing, for example, you would need to look at what's the lawful basis for that additional purpose. Well, the additional purpose of asking for email marketing would be consent. You would have to ask their permission. So if you are looking at thinking, actually, here's an opportunity now to collect more data about our customers and do more things with that data, keeping it for the purposes of the guidance for coronavirus is one thing, but you'll need to think about what's the lawful basis and probably for other things like marketing, and that's going to be consent. So you will need to have a consent mechanism, and that consent mechanism needs to meet the GDPR requirements about openness and transparency, somebody giving you a positive confirmation that they wish to give you that permission for the purposes of you using their data in that particular way. So don't see this as well, you can see this as an opportunity to collect data that you would not collect before and do something else with it, but you need to bear in mind that only the obligation to collect it according to what the guidance and the government require is only one purpose. If you want to use it for other things, you've got to be very clear to the individuals when they hand that data over that you're going to use it, you would like to use it for other things, and you'll probably need to ask them consent for the purposes of doing those other things. What are you going to be recording? Well, I think, you know, it's not entirely clear. I mean, you guys might already have a clear understanding of what the expectation is to, you know, what contact information is. Is it a name and a phone number? Is it a name and a phone and email address? Is it a name and a postal address? My understanding from what I've seen is that it's very much about, you know, some way for somebody to contact, and if phone's the right way, then you would be collecting phone numbers. But there are lots of other uncertainties as well, and you might need to bear this in mind. Some of you might already know. So somebody just asked me a question, which I'll come back to in a second. So is it everybody that's coming through your door? Or if, you know, if somebody says, hey, I'm here with 10 friends, we're all part of the same family, we're social distancing, etc., do you just take the lead person's details and the assumption that he knows that he's with these friends, that they all live together in the same house or whatever, or do you have to take all of the details of each individual? Again, the government guidance might set that out for you, but that's a decision you need to make. I would, you know, I think from doing your part from the COVID secure aspect is probably about recording everyone. But there is, you know, I have been asked, does that mean I have to record everyone or just the lead person? I think you have to record everyone because you need to have contact details. And given that I think it's something like only 75% of the people that they're currently tracing are actually responding to that tracing, is probably an indication that if you just had the lead party, then you're missing out on a wider group of people potentially. How are you recording the information? You know, you're going to have a paper list for somebody to sign on, in which case, what are the considerations there? How do you keep paper lists secure? One customer comes in and see everybody else on the list, that would be a breach of data protection. You know, where does that piece of paper get stored? Is it stored securely when it's not being used, and so forth? If you're using an app, how's that app processing the data? What, you know, where in the world is it stored? If it's a cloud-based service, is it stored on the device? How do you keep that device secure, and so forth? How do you access the information? And similarly, if you store the data on a computer, so you've got a login desk, when somebody comes in, you write it into a spreadsheet, how are you securing that spreadsheet, and so forth? So think about how you're recording that data and how long you're going to be keeping it, and that's the retention, which the government says is 21 days. So you would need to think about how you're going to implement that in a practical sense, but you would need to have a process that requires you to be able to basically cycle out old data after 21 days. So how are you doing that? How are you destroying it securely? And how are you making sure that it actually is deleted? Now, just going back to the question that I've just been asked, which was from the previous slide about consent. Somebody says, is it possible that consent can be gathered verbally? It is, but because of the accountability principle, you have to be able to demonstrate that you had a process in place to gather consent verbally. So if you were questioned, you can say, well, this is the process that happens. We will talk to somebody, they will say, yes, I consent for you using my data for this purpose. And this is what they would have been told about that purpose. So if you're relying on consent, you've got to set out the background as to what it is you're asking them to do, so they can make an informed decision and take a positive action. So you have to demonstrate that. The problem with verbally, of course, is that you don't have things written down to be able to do that, but that doesn't mean you can't record consent if it was given to you verbally. You just need to be able to demonstrate that that process is in place and it was always being followed, so that when somebody questions they never gave you consent, you can say, yes, you did, because this is what happened. You came into our, you signed up here, and you would have had to tick this box before we had your consent, and so forth. Or we would have asked you over the phone and made it clear to you, this is what we would have said, and so forth. And that's what GDPR consent is all about. So as long as you can demonstrate that, it doesn't matter how you take consent. You just need to be able to demonstrate that it was given to you. Now, the individual's rights, you need to think about how are you going to manage those or allow those individuals to exercise their rights. So probably the key worry I think that you will have is getting across to the individual what it is that you're going to be doing with their data. So if you're purely collecting it for the purposes of the coronavirus guidance and keeping it for test and trace, then the right to be informed is about explaining that. Now, the problem is that there are lots of other things that you need to explain. So you have to be clear that you're collecting the data because the guidance asks you to, and it may be shared with the NHS Test and Trace. You need to be clear about how you're recording that data, how it's going to be stored if you're using third-party processors like an app or some online system. You need to be able to explain that they've got all these individuals' rights. So probably the key thing is at the point you collect the data, it is perfectly okay to signpost a main privacy policy. So you could have a sign up on the wall next to where people are giving over their data and making it clear and setting all that out. You should be signposting it as much as possible, but there's quite a lot that needs to be got over, and probably a lot more than somebody coming into your venue, and they're probably, certainly to start with, I'm sure, very excited to be able to go out and go in and enjoy a drink or have a coffee in a cafe or whatever. They're not going to be wanting to read long lists or listen to you while you explain to them all their rights and what they can do. So be prepared with a privacy statement that sets out, or update your existing privacy statement that says, when you visit our premises, this is what will happen, and this is what happens with that data. We'll only keep it for 21 days. We will only ask you if we want to use the data for other things, we'll only ask you if you give consent and all that kind of thing. So you'll need to either amend an existing policy and refer to that, or if you haven't even got one at the moment, you'll need to put in place a privacy policy that covers everything, and in some way, when you're getting the sign up of the information for the contact purposes, you've signposted that privacy statement. Or it could be as simple as, hey, we're just recording this because the guidance has asked us for test and trace purposes, we just need your name and your telephone number. If you want to know more about what we're doing with your data, we're not planning on using this data for anything else, but we've got a privacy policy. You can find it on our website, or it's printed out on a piece of paper stuck to the wall over there, or whatever. Potentially, an individual could ask you for details about how you've collected their data. So if they want to know, maybe they serve you the subject access request on day 22 to see whether you really did delete it, and you can't delete stuff just because you realize you should have deleted it and you haven't, to avoid dealing with a subject access request. But you need to be prepared for the fact that somebody might issue with a subject access request and ask you, well, I know that I gave you this information for a particular purpose, but what else have you got about me? What are you using it for? Somebody might ask you to delete that data. Now, this is a bit uncertain, because this will depend on how you want to approach it. If you're working on the basis that there's a legal obligation for you to keep that data for health and safety purposes in line with the guidance, but it's health and safety law that dictates that protection of other customers and individuals, then you can object to the right to erase this. You can say, look, I'm not going to erase it. We're required under health and safety legislation to keep it for 21 days according to the guidance, and therefore that's what we were doing. We will delete it after the 21 days. And somebody has a right to object. Now, I don't know what the answer to this is. If somebody says, look, I'm not giving you my contact details, I'm guessing there'll be some guidance from the government about this. Does that mean you can't let them in the premises, or do you have to just note that somebody came in and they refused to give their details? I don't know, but even if you're collecting data about an individual which could lead to them being identified, you have to consider the implications of whether that's personal data or not. For example, if you have CCTV and you're able to say, well, actually, it was this person who came in, we don't know who he is or she is, but there's this image that we've got from our CCTV. So that there's some issues there. Hopefully will be cleared up by the government guidance, but you might just be sitting there hoping that somebody doesn't object. And that objection is more likely to come at the outset of them turning up at your premises and saying, I'm not going to give you my details, regardless of what the guidance says, in which case you'll have to weigh that up against health and safety legislation, I guess. So where does accountability come into all of this? Well, you need to keep some documentation, so you'll have to be very clear about what data you're collecting anyway, and you'll just need to update your existing records to reflect the fact that you're now collecting this data for the COVID guidance. If you haven't got policies in place, even if it's just a basic data protection policy, get something in place and make sure your staff are fully up to speed with what data protection means. The last thing you want is people coming in and giving their data over because of this process and it gets misused, either by a misunderstanding or an accidental staff not understanding what they should be doing from a security point of view. So if you haven't trained your staff about data protection, they don't need to become data protection experts, but they do need to understand the basics of data protection, and you should be relaying the importance of that across to them, particularly if this is something you wouldn't normally do in terms of collecting customer data. If you're using a third-party processor by maybe using somewhere to store the spreadsheet that's got the list on, or an app that you're using, consider the fact that they could potentially be a third-party data processor, and you've got to carry out due diligence to show that you believe they are GDPR compliant and that there's a contract in place. The obligation would be on you as the controller, but it's not unreasonable for a processor to say, hey, don't worry, here's a statement of why we're compliant, and here's a data processing agreement, which if you're going to be using our app or our service, you have to agree to, and that binds you within those requirements as required by GDPR. Probably talking about it now isn't necessarily the right time to do it, but I couldn't quite work out the most effective way. But the whole thing should be bound by a data protection impact assessment. So that's the square right at the bottom of that circle. So data protection impact assessments are basically risk assessments, and part of what I've talked about here is kind of doing the thinking for you, which would be in a data protection impact assessment. So that's saying we're processing data in this way. These are the risks from that processing. How do we mitigate those risks? So, staff not knowing what they can and can't do with their data, that's a risk. We can train the staff to tell them not to do anything other than record it and lock it away as soon as they've finished at the end of the day, or, hide the list so that other people can't see it, and those kind of things. And this is all around the concept of data protection by design and default. And this is about making sure that you consider data protection at the forefront of any project or process that you decide to introduce or decide to do. And data protection impact assessments is a great way of understanding what are the risks and how you mitigate those risks. So certainly, as I say, a lot of what I've been talking about are sort of kind of doing that for you in terms of considering some of those risks, but you ought to have that documented in some particular way. There's a template you can download off the Information Commissioner's website, that's ico.org.uk. But it can be just a general document or a list of risks in a risk register or whatever you might do from current risk management. You need to make sure you maintain that compliance. So, your staff you need to make sure all your staff are up to date with what they're doing and how to manage that data. You need to make sure that it's still being managed appropriately according to GDPR. Maintain that compliance. If the guidance changes, you need to stop taking the data if they say there's no need to do it anymore. If the government changes its approach with what you should be recording, then you need to pay attention to that and also the data protection implications, whatever those changes might be. And it's possible that the Information Commissioner might publish some guidance to help you as well, either before the 4th or over the next few weeks. And finally, if your list of customers or visitors to your premises gets lost or copied or stolen, or somebody sees it that they shouldn't do, that's a breach. You've got to consider the implications of what the risks are to the individuals from that breach. You know, is it data that could be used in a way that would be harmful to the individual? And that harm isn't just about financial risk. It could be identity theft. It could be physical risk. It could be mental risk, and so forth. Right, so I've just got a question come through. If we offer takeaway as well as sit down, do we need to take details of a customer just has takeaway? So my understanding, and you might need to talk to a health and safety expert about this, but my understanding is that the guidance applies to takeaways as well as pubs and cafes and things. So I think it's everybody that's going to be at your venue, which personally I find quite curious, because premises have been, pubs have been doing food as takeaway, and so cafes and other organisations, when they sort of changed their business when we were in lockdown to be able to for people to socially distance queue and pick up food. But my understanding is the guidance includes takeaway. So I'm guessing that the answer to your question is yes, you'll need to record details of people that are coming in for takeaway as well as those coming to sit down. But you might want to just check the guidance in a bit more detail about that, and if necessary, talk to a health and safety expert who might know a bit more about that. Okay, so that's applying accountability. What security things should you consider? Well, this is going to really depend on the medium by which you're recording. I've touched on some of these already. If you're using pieces of paper or on a list and writing down details, what if you write down the details incorrectly or illegibly? That could potentially be considered a breach, and that's a breach of GDPR, not necessarily of the guidance. What about other people seeing the paper because it's on a desk when somebody comes in and another customer can see it, or when they sign, when you fill out the form, you can see somebody else's data on a further up the list, or whatever. However you're doing it, you've got to consider that you need to minimize the chances of somebody else seeing that data. And of course, even though it's on paper, you really ought to secure it as well. So that's not leaving it lying around when it's not in use. It's about keeping it locked away or out of sight to minimize the risk of a security breach. If you're using app, then it's potentially you've got device security where the app's running. You've got to think about whether they're a third-party processor and carry out the due diligence and get a contract in place. Understand where in the world the data is being stored. If it's being stored with an app that stores it in China, then have you checked to see whether there are the contract clauses that are needed for that kind of data transfer covered, because that would be a requirement as well. So understand where in the world it is. And if you're storing it in a file on a device, again, as with all of these things, presumably not paper because you wouldn't have passwords and security controls per se, but with apps and devices, how do you mitigate the risk? And GDPR talks about security as being implementing the most appropriate technical and organizational security measures, which is about assessing what the risks are. If you, for example, store the customer contact details on a device which overnight you lock in a cupboard in your cafe which is locked, that's probably appropriate. You wouldn't need to also pay for a security guard to stand outside just in case somebody tried to break in. But if somebody did break in and got into the cupboard and stole the device, what security protections are in place on the device to prevent somebody getting access to the data? And that might not just be passcodes and security locks and things on the actual device. If the device has detachable storage and that's where your data is stored, for a hard disk in a laptop, for example, could they whip that hard disk out, plug it in, and then see the data, in which case you would need to think about encryption of the device and so forth. So it's that kind of out-of-the-box thinking that you have to think about when you're thinking about what's appropriate technical and organizational security. Organizationally, it's about making sure that staff understand they have to lock it away, or that they can't just leave it lying around while they're cleaning other tables or serving another customer or whatever. And something else which from a GDPR point of view, you will also need to worry about, and I didn't quite know where to put this in as a separate slide, so I added it as a little blue box on the corner of this one, is making sure you understand how you're going to be dealing with NHS Test and Trace. If somebody rings you up and say, I'm ringing from NHS Test and Trace, can you tell me the names and details of somebody who was in your store, your venue in the last hour? You need to be sure that really is NHS Test and Trace. So how does that get verified? How do you check that? And that might be understanding more, again, from the government about how that interaction will happen. If the police turn up and they want to get access to the data because they know that you're now collecting this, is it lawful for you to hand it over? Is that the reason why you've got it? Have they got the legal authority to ask you for it? And so forth. If somebody rings up and says, I think my wife was in your cafe yesterday, can you just confirm you'll have your test and trace list? Are you sure that that individual was given permission to the husband to get that access? Probably not. So somebody can't ask a subject access request on behalf of somebody else without you confirming with the individual that it's okay to hand that data over. So I'm possibly overthinking the sort of negativities of you having to store this data, but there's quite a lot of things you need to have in place, checks and balances, and be absolutely clear that you only have that data to hand over to test and trace, or if you're compelled by law to hand it over in any other way, like, for example, if law enforcement turn up with a warrant or an official request for that data. So you'll need to be absolutely certain that your staff, and this goes back to the training and the policies again, fully understand that contact data is purely for the NHS Test and Trace. Don't hand it over unless they follow a proper NHS Test and Trace request protocol, and don't just hand out the data willy-nilly to anybody who might ask for it. So I sort of summarised this into 10 key points. So this is my last slide, so there'll be an opportunity to pick up questions in a second. Basically, decide on how you're going to be recording the data, carry out your risk assessment, so that's a data protection impact assessment, or you might have heard the phrase DPIA, same thing. Basically understand what those risks of that processing are going to be and how you're going to mitigate them, and hopefully that the conversation, the presentation I've just done will help you in thinking about those. Understand what your lawful basis is. As I said, I think legal obligation is probably the most appropriate, but it's not entirely clear, and the government might give some advice accordingly. Put in place some kind of statement. It could be a verbal statement, but you should already have a privacy statement or privacy policy or notice. It all amounts to the same thing, and make sure you've got a part of that sets out what happens if you come into our venue and we take your contact details. Carry out due diligence on any third-party processes you might have, remembering to think about that wider definition of processing includes storage and the use of third-party apps and online websites. Put processes in place to deal with common compliance activities, and they will include for things like dealing with a breach, subject access requests, requests to erase data, making sure that you are dealing with who you think you're dealing with, particularly making sure it's NHS Test and Trace that's asking, and not somebody trying to get you to hand over data when they shouldn't be. Put in place a process to ensure the data is deleted securely within the required time, which is 21 days. Train your staff on the basics of GDPR, and they don't need to be experts, but they should understand the basics and how it applies to what they're doing, and have policies backing that up as well. Make sure you have a process or a policy in place with how you deal with test and trace. For example, only one person deals with them directly, and that person understands what they can and can't talk to NHS Test and Trace about, and understands perhaps the process. And just keep up to date. Undoubtedly, there'll be some guidance from government about the best ways of doing this, or even the preferred ways. There should be some documentation that tells you how the NHS Test and Trace will be in touch with you, and there may even be Information Commissioner guidance or advice about how to deal with some of the GDPR implications, which hopefully will support a lot of what I've covered already. But if you do need help, then that's what I do for a business. I provide support helplines, and I basically can do that either by supporting you doing it yourself. So I have online resources backed up with support via a Facebook group, or at the other end of the scale, I can provide, I can do some work for you as well. So I have a what's there is the GDPR DPO helpline, which is basically unlimited email and phone support, up to 4 hours hands-on help, and some online resources as well. And that can include things like carrying out a review and making sure you get all of this right. It can include training your staff, and you can use the 4 hours to pretty much implement anything that you might need help with regards to these particular issues. Or I can just sit and run through it with you in a lot more detail, virtually sit, of course, through Zoom or whatever you might need, and give you the help that you need when you need it, on a sort of pay-as-you-go ad hoc basis. And if data protection and coronavirus are your thing, I'm running another webinar tomorrow afternoon. It's another free one. It's at lunchtime, in fact, and I'm looking at advice around GDPR when it comes to employers getting their employees back to work, and some of the questions and issues around what happens with if you're recording information. So if a member of staff rings you up and says, I think I might have coronavirus, I've applied for a test, how do you record that? You'll be processing special category of data. What do you do if you're testing employees with their temperature and recording their temperatures? Can you do that? What are the implications with GDPR and stuff? So very similar to sort of approach to what we've gone through today, but more focused on employers getting their employees back, and the kind of processing of special category data, because it will be health related in this instance. So if that's of interest to you, go to my website, markgracygdpr.co.uk, look at the training events section, and you'll see a link to that, or you might even find it on Eventbrite. And you're welcome to join that as well. And if the time doesn't work but you're interested, then sign up anyway, and you'll get a copy of the recording as you will with today's session. So that's pretty much everything I wanted to go through. What I'm going to do is I'm going to stop the screen share, and I'm going to stop the recording. The questions that came through chat I've picked up as we went through, so if there's anything else, then we can do that either through chat, or if you want to unmute yourself and ask a question, then probably best to put your video on and raise your hand so that I can see you asking